should January 6th disqualify Donald Trump from running again for president. A group of voters are hoping to make Massachusetts the latest state to kick Trump off the primary election ballot. They're suing to make it happen, citing the Capitol riot and a section of the 14th Amendment which bans insurrectionists from holding office. I'm joined now by one of the attorneys behind that suit, Shannon Liss-Riordan, and by Austin Sarat. He's a legal scholar, professor, and chair of the political science department at Amherst College. Thank you both for being here. Shannon, I alluded in broad strokes to the legal rationale for the court action that you are bringing, but I want to get you to describe it in as much detail as possible. What is the legal basis, as you see it, for not allowing Donald Trump to be on the ballot here in Massachusetts?
So there are a number of different kinds of prohibitions to various candidates being elected to office. For the presidency, there is a requirement that you be 35 years old. One of the other requirements that's set forth in the 14th Amendment to the U.S. Constitution, Section 3, is that you cannot be an insurrectionist. If you have taken a prior oath of office and defied that oath, you're disqualified. So we are very proud to have brought this challenge on behalf of a number of voters in Massachusetts across the political spectrum, Republicans, independents, Democrats. We're working with the organization Free Speech for People, which has been coordinating these challenges across the country. And we are following the specifics of the Massachusetts statute, its general law, Chapter 55B, to raise this challenge, which we have filed with the Massachusetts Election Commission, which will have the first crack at making the decision here in Massachusetts.
You mentioned other challenges that are similar occurring around the country. I want to pull up a graphic that was put together by the news service Axios. In this graphic, we have states that have said President Trump actually cannot be on the ballot. That's pending appeal. Maine and Colorado, they're in orange. But all those blue states are states where comparable challenges have been brought and dismissed. And Shannon, I want to ask you before we get to you, Austin Sarat, if the legal rationale, constitutionally speaking, is as clear as you paint it to be, if it's a black and white issue, why are so many of these challenges not succeeding in other states?
Well, yes, we do think the legal issue under the Constitution is clear. The challenges that have not succeeded in other states have been on procedural grounds. For example, there is a long shot Republican contender who has been filing a number of these challenges around the country. His challenges have been knocked out based on standing, that he doesn't have standing to bring such a claim. There are other procedural issues that have been used to reject the challenge. For example, that it can, in certain states, it can only be made before the general election rather than the primary. That's not the case in Massachusetts. So the two states where there has actually been a substantive final finding on this are Colorado and Maine, which correctly held that the 14th Amendment applies and that Trump is disqualified.
Austin Sarat, do you believe that the implications of the 14th Amendment for President Trump and ballot access are as straightforward as Shannon Liss-Riordan thinks they are?
So I do, but I want to add a little bit of nuance to what Shannon just said. I find her argument persuasive and powerful. Legal issues of the kind that we are dealing with are seldom simply black and white. After all, in Colorado, the decision was made by 7 members of the Supreme Court, and it was decided 4-3. In Maine, the Secretary of State said off the ballot with Donald Trump. In California, the Secretary of State, looking at the same set of facts, different law, said no, he would remain on the California ballot. So I think this is it's a complicated legal question. I believe that Donald Trump should be disqualified under the 14th Amendment, but we know that there are a lot of wrinkles to it. So even the way Shannon described it, she says, is an insurrectionist. The language of the 14th Amendment says engages in insurrection. So we're going to see arguments about whether, quote, he engaged in insurrection. We know that there are complexities around whether or not the 14th Amendment applies to the office of President of the United States. I happen to think it does. But there's a mixed history, if you go back and look at the origins of the 14th Amendment, about whether they intended it to apply to the President of the United States.
And we should mention it has its origins in the post-Civil War period, correct?
It does. And again, I think at the time, if you look at that history, they were most concerned not about the President of the United States. They were most concerned about people in the South who had engaged in rebellion against the United States being able to run for and hold office.
And tell me, I think I'm remembering this correctly. I don't believe the presidency is actually mentioned explicitly in that.
It is not mentioned actually explicitly, though it's very hard to conceive that when they use the phrase officer of the United States, that would not apply to the president.
Shannon, when I spoke with Secretary of State Bill Galvin about this a couple weeks ago, before you filed your challenge, he told me, and we should mention he's the state's top elections officer, he said essentially that given the way things work in Massachusetts, he does not have the latitude, the state doesn't have the latitude to consider eligibility as it's weighing who to put on the ballot. And we can play a soundbite of him making that argument in a slightly different context.
It's only the United States Supreme Court that could rule on the issue of eligibility. I think there's been a lot of confusion between the ballot access issue and the issue of eligibility. If, in fact, the Democratic Party had chosen to include, for instance, either Barack Obama or Bill Clinton amongst their candidates, I would put them on the ballot because I'd be required to.
Shannon, how do you respond to that objection from Secretary Galvin?
Well, it frankly just really doesn't make a lot of sense. The role of the Secretary of State and the Ballot Commission is to make sure that the candidates on the ballot are people who are eligible to serve in that office. It makes no sense to have someone on the ballot who could not take office if they were elected. So, for example, there are plenty of Democrats who I'm sure would love to see Barack Obama run again. He's not eligible to run for the presidency again because he has already served 2 terms. It makes no sense to say that, well, we'll see, we'll put them on the ballot, we'll see what happens. If they're not eligible to serve, then we'll deal with that later. So what does that mean? Next January 6th, we're going to have elected someone who's ineligible to serve. What do? Hold a new election? That's just absurd. So I disagree with Secretary Galvin that this is a question about who can serve rather than who can be on the ballot. And also, it is the duty of the designated state officials under state law to implement our state election laws, but they have to be in accordance with the highest law of our land, which is the U.S. Constitution. The U.S. Constitution takes precedence over state laws, and if someone is disqualified from office by the federal Constitution, then state officials responsible for ensuring proper ballot access are beholden to that higher law.
Austin Sarat, you wrote a piece recently for Salon in which you argued that the Supreme Court ought to reckon with this. They're going to be taken up in early February, but that they need to rule, I was going to use the term aggressively, which I don't think is a good legal term, but that they need to engage directly with the substance of the question at hand here, as opposed to issuing a ruling that doesn't really get to the meat of the matter. How concerned are you that they're going to do the latter, that they'll find a way to not entirely say whether the president is eligible, or forgive me, the former president is or is not eligible?
I'm very concerned. If I was on the United States Supreme Court and worried about the legitimacy of the institution of the United States Supreme Court, I think I'd be looking for a procedural off-ramp. I'd be looking to say something that avoided the major issues. Congress needs to make a determination, or the president is not covered under the language of officer of the United States. But I think that would be a dreadful mistake for them to do so. And while I have a clear view about what I think the right answer is in the case, I think that Donald Trump should be disqualified under Section 3 of the 14th Amendment. I think it's really important for the court to tell us one way or another to resolve this question. Is Donald Trump someone who engaged in an insurrection? Is he qualified under the 14th Amendment to serve as president of the United States? Without that, the election will be shadowed with doubt about whether or not one of the two major party candidates is really eligible to serve. And let me just say, and I wonder whether Shannon thinks this is true, the Supreme Court's kind of in a no-win situation. If they rule against Donald Trump, there will be massive demonstrations, and Donald Trump will make war on them. If they rule in favor of disqualification, they're not going to earn any points with progressives who are going to suddenly say, well, we don't care about Dobbs, or we don't care about their affirmative action decision. So the Supreme Court is in a real bind one way or another if it makes the kind of ruling that I believe it ought to make.
Since you broached the question of whether Shannon agrees with that analysis, let's get your take on that, Shannon. Do you see this as a no-win proposition for the court in particular?
Well, I, as a lawyer, I'm a firm believer in the rule of law, and I would like to think that the Supreme Court will actually look at the legal issue. There are a number of good textualists on the Supreme Court, and if they abide by their textualist background and leanings, they should apply this constitutional amendment as written and as it was intended to disqualify him. So I'm not so concerned about their political calculus. I will say that the court is obviously in a lot of jeopardy right now. There have been real attacks on its integrity. Serious concerns have been raised about the court's integrity. I think that this would be a welcome opportunity for the court to do the right thing and apply the law as written and be the proper neutral umpires they should be and call it like they see it. So I think that is all we can hope for. We were pleased to see that the Supreme Court agreed to take this case. I agree with Professor that this is an extremely important case. I would like to see the Supreme Court address the issue head on. We are continuing with our challenge here in Massachusetts because under the law, there's a particular timing framework we have to abide by. The commission has to, well, they can't start considering the challenge or hold a hearing until January 22nd, but they must decide on our objection by 5 p.m. January 29th. That is before the Supreme Court will be hearing arguments here. So we need to push forward with this. And we don't know what the Supreme Court is going to do. We hope that they'll address the issue head on. And this is the only way that we could get, if we're successful, get a ruling that will apply across the country that would keep Trump off the ballot, period, in this upcoming election. But we don't know. As a professor said, they could very well decide on narrow procedural grounds, something that happened in the Colorado case that ducks the bigger issue. But the fact that they took the case gives us some hope that they did it quickly and they recognize it's an important issue where they need to get to the merits quickly.
I'd like to get each of you, just briefly, we've got about a minute left, to weigh in on one of the objections that has been brought up repeatedly in response to these challenges. Basically the idea that it's not a question for the courts to decide, it's a question for voters to decide. The Massachusetts Republican Party is among the voices making this argument. They tweeted after you filed your challenge, Shannon Liss-Riordan, the Mass Republican Party opposes this latest effort to remove Donald Trump from the ballot in Massachusetts through administrative fiat. We believe that disqualification of a presidential candidate through legal maneuvering sets a dangerous precedent for democracy. Democracy demands that voters be the ultimate arbiter for suitability for office. Shannon, briefly, and then Austin, briefly. What's your response?
My response is this is a legal issue. This is not a political issue. Just like someone who's 34 years old is not eligible to serve as president, this is a legal issue, and that's what we have courts to decide the legal issue. So it wouldn't make any sense to say, well, let's see if the voters want to put this 34-year-old on the ballot. It's just not a legal qualification.
Okay, Austin Sarat, you get the last word here.
Well, I'm a college professor. I love having the last word. I fully agree. And what I would say is simply what the Republican Party wants us to believe is that democracy is a free-for-all. It is not. It's a political system set up with certain rules and norms. And for democracy to work, we have to be committed to respecting those rules and those norms.
All right, Shannon Liss-Riordan, Austin Sarat, thank you both for talking this very complicated and important issue through.
Thanks for having me.
Thank you for having me.